Point number 1. Introduction. FIR, that is First Information Report, sets the criminal law in motion. It is the first piece of information received by a police officer about a cognizable offense. Section 154 of the Criminal Procedure Code deals with FIR. Point number 2. Meaning. FIR meaning is not defined anywhere in the code. But the report under Section 154 is usually referred to as the First Information Report. It is the information given to the police relating to cognizable offense. Point number 3. Object. The most important object of a FIR is to obtain early information of alleged offense from the informant and to put into writing the statement before his memory fails or before he gets time to decorate it. The information is very important to the accused too, as he comes to know the facts stated about the occurrence of the incidents. It safeguards him from subsequent variations and additions. Point number 4. Nature and scope. It is not necessary that the information should be given by an eyewitness. It may be hearsay in nature, it may come from an anonymous source, it need not be in writing. It cannot be given by a telephonic message. Case. Tapinder Singh vs. State of Punjab 1970. Point number 5. FIR distinguished from complaint. FIR is given to a police officer and it should be related to cognizable offences. An investigation is started by a police officer upon receiving the information. FIR may be given by any person including a police officer. If magistrate does not choose to take any action, he need not record reasons or pass any action. A complaint is given to a magistrate. It may relate to cognizable or non-cognizable offences. Magistrate takes cognizance on complaint made to him. A complaint does not include police report. On receiving a complaint, magistrate has to decide whether to permit the complaint or not. He may make inquiry or order an inquiry or dismiss complaint after recording reasons.
Point number 6. Requirements of a FIR. FIR must fulfill the following conditions. 1. It must be given to officer in charge of the police station. 2. It must relate to commission of cognizable offense. 3. It must be the earliest report of commission of offense on which investigation starts. 4. It must be in writing or reduced in writing, if oral, and must be signed by informant. 5. The information reduced in writing must be read out to the informant and the copy of it should be given to the informant free of cost. 6. The substance of the information must be entered in the book called Station Diary or General Diary. FIR may or may not contain all details and particulars as to the incident. It is sufficient if it indicates commission of crime so as to enable the police to start investigation. Elaborate account of everything what happened is not necessary.
Point number 7. Delay in filing FIR. Neither CRPC nor the Limitation Act prescribes any period of limitation for filing an FIR. A mere delay in filing an FIR is not enough to reject the case of the prosecution. But long and unexplained delay may create doubt or raise suspicion as to how the incident had happened or were accused person involved or not. In such a case there is a possibility of false implications. Delay in forwarding the FIR to the magistrate by the officer in charge may be fatal. Point number 8. Evidentiary value of FIR. FIR is an important and valuable document, but it is not a substantive or primary piece of evidence of the facts stated therein. It can be used for corroboration under Section 157, Evidence Act 1872, or contradicting statements under Section 145 of the Act if the informant is called as a witness at the time of trial. Case. Ravi Kumar vs. State of Punjab 2005. The evidentiary value depends on the facts and circumstances of each case. FIR may become relevant under Section 8 of the Evidence Act. First information report, it is well settled, need not be an encyclopedic one. It need not contain all the details of the incident. Case Bishna alias Biswadev Mahato or Oz vs. State of West Bengal 2005. Point number 9. FIR by accused. Sometimes it may happen that the person lodging FIR is charged with the offense for which the report was lodged by him. Such contingencies may arise in the following cases. A. Where FIR is confessional in nature. B. Where FIR is not confessional one but the investigation on the basis of such report reveals involvement of the person lodging the report in the crime. The settled legal position is that if the report is confessional, it is not admissible in evidence. But if it is not confessional, then it is admissible in evidence against the accused. A statement contained in FIR furnished by one of the accused in the case cannot be used against another accused. Point number 10. First information in other cases. Section 155. When information is given to officer in charge of a police station about commission of non-cognizable offense, he should enter substance of such information in prescribed book and refer the information to magistrate. He cannot investigate a non-cognizable case without the order of the magistrate having authority to try any such case. But if case is related to two or more offences, one of which is cognizable offence, it shall be deemed to be a cognizable case.